that I need to find a...
Oh, I'm sorry. It's our motion. This is the motion objecting to mother's superseding objection.
Right. What day did you file it?
What day did I? I filed it. No, I don't have the date I filed. I have the date that I signed it. But
I got a lot of tabs to turn to, so let me see if I can find it.
Or if you just tell me what tab you're on, I can go to that one. So I can do whatever's easy. I think I filed them all the same.
All right, well, the first motion of any kind that I find filed in this file is the motion to dismiss the counter petition for civil contempt filed February the 6th of 2026.
I can do that one. Judge, that's one where there was a initial petition, there was an answer, and then Ms. Huey decided to just do an amended one without asking for permission from the court to do that. I understand she's pro se, but that's the reason why we asked for that.
Ms. Huey, the law, you're unfortunately held to the same standard as if you had a lawyer representing you, and under the rules of civil procedure, once a petition is filed and a responsive pleading, an answer has been filed, then you cannot amend the original petition without leave of court. You would have to file a motion asking for the court to allow you to amend your petition and then have that heard before you can actually file that. So I have to grant the motion to dismiss the counter petition for civil contempt, but you're free to file a motion to amend, and normally that would be granted. So it seems rather circuitous and unnecessary to do it this way, but that is what the rules require.
Your Honor, may I have permission to respectfully request leave to amend here in the hearing?
You can respectfully request what?
Permission to amend that petition here in the hearing, or would you need
You
that?
have to file a written motion to amend under the rules.
Yes, sir.
So if she files that and serves that on me, that might be something we can just agree to.
If you file your motion to amend and set forth the reasons why you want to amend it, then serve that on opposing counsel, and I think at that point you would be entitled to have it heard if he doesn't agree, but I would think he would likely agree. So. All right. Then we have the motion to dismiss the counter petition for civil contempt that Ms. Huey has filed. That was filed February the 6th. That was actually the one we were talking about. And Ms. Huey, you have filed a motion to dismiss the counter petition for civil contempt.
Yes, sir.
What is your basis for that motion?
Because I gave notice to regarding the move, and there was no written objection, there was no verbal objection, and I followed the rule of the parenting plan as I understood it.
Mr. Belcher, do you have anything to respond?
No. Well, let me say this. As far as I don't have that.
You might want to turn that microphone towards you because
Can you hear me okay?
Well, I'm worried more about her than me.
I'm talk really loud, so I usually have to, but just to make sure that she gets it. As far as that goes, I would argue that is a case. That is a material thing that should be set at the hearing for we have a number of hearings that we maybe do, but that's not for today. I mean, that's for that'll be an evidentiary hearing to determine that.
Ms. Huey, the civil contempt petition that's been filed is a factual issue, and it's also a legal issue. And for that reason, just to say that you want to dismiss it because you felt like you complied with it, that's an allegation of fact which will have to be proven at a hearing. So while at that hearing, I'm going to pass your motion to dismiss, and we'll just reserve that for the hearing on the motion for contempt. To allow both sides to be fully heard on that. All right, the next is a motion objection to interrogatories and requests for admissions that was filed March the 9th. I show it was supposedly set from April the 8th. Did you appear on April the 8th and have a hearing?
No, we moved it, Judge. We moved it to today. We've not heard any of these. Is that our motion objecting to the mother's superseding discovery responses?
The one you filed March the 9th, 2026. Motion objection to interrogatories and requests for admission.
Correct, Judge. That's the one where the mother filed 3 separate petitions in this case to modify parenting plan, modified child support, and conversion of funds. We answered the interrogatories and requested for admissions, and then 7 hours later, she sent us 25 more interrogatories, 16 more requests for production of documents, and 87 additional requests for admissions. So what I would ask, Judge, she did that once. I guess maybe she didn't like the responses, so she decided to take a second bite of that. And I would argue that that is not proper.
There is a rule, both a local rule and a rule of civil procedure that somewhat limits the amount of questions and interrogatories and requests for admissions that you can submit. I'm going to grant the objection to the subsequent or superseding set of interrogatories. But again, if you feel that there is an additional need for something that is not fully answered in the first set of interrogatories, then you can file a motion asking for the court to approve additional discovery.
Thank you.
All right. Then we're moving to the motion for a temporary parenting plan, and Ms. Huey, I've already dealt with that. I cannot adopt a new parenting plan on a temporary basis without a full hearing.
Yes, sir. And may I just clarify, my intent is not to limit or restrict the parenting time or that he's in any danger. I'm simply seeking a parenting plan that is reflecting the reality because we've had substantial change. My older son has reached age majority. It's just dealing with our younger son and trying to reflect actual parenting arrangements and reducing conflict and communication issues was my goal.
And I understand that, and that's a, an admirable goal that you may have, but all I'm saying is that unless it's agreed to, I cannot grant or even conduct a hearing to adopt a temporary parenting plan absent showing of a substantial risk of harm or injury to the child. So we'll reserve that, and perhaps you two can come to an agreement in mediation or whatever. There's a supplemental motion to determine a child support arrearage.
Your Honor, that was the mother's motion. She's trying to seek set an arrearage from a date of divorce to present. I would argue that's also premature. We haven't done any mediation, and that would be something for a final hearing.
Ms. Huey, do you want to be heard on that? It is typical that would be a hearing that would be conducted. That would be an issue that would be heard during the final hearing.
Yes, sir. I understand that now. I was just simply seeking I didn't realize that was part of the final hearing. I was seeking to just bring matters before the court for resolution.
All right. Then we have a supplemental motion for reimbursement of child-related expenses. Again, this would be, in my opinion, a part of the final hearing as well. If there are additional expenses, child-related expenses that need to be addressed, then that normally is done at the final hearing. And it will be based on what the prior temporary parenting plan or permanent parenting plan provided. Now we're looking at motion to compel discovery responses that Mr. Huey has filed.
That's correct, Judge. We, on January 20th, we sent interrogatory responses on a number of questions, and I can submit these if you want to later, and you could do that, but there were several things that were just not answered. She objected to it, and she just didn't answer. There was, we think, one interrogatory and production of documents. There's 1, 2, 3, maybe 6 of those, and she just objected to them and wouldn't answer them. And like for instance, one, I said number 20 of the interrogatory, please state with specificity all complaints and allegations on which you intend to rely on as grounds, listing specific instances of misconduct by father, and state the names and addresses of persons who witnessed or have knowledge of any instance that you have listed. And she just wouldn't answer that one, objected to that. And then do you want me to go through each one, or do you want to rule on each one of these?
I don't want to rule on them at all. but I will do what I'm required to do.
Well, fair enough, Judge. So we just want to know what she's going to say bad about the father, and we need to know what things she's going to rely on at trial, and that was the point of that interrogatory.
Ms. Huey, under the rules of civil procedure, when I first started practicing law, these rules had just been adopted, and older attorneys used to moan about the fact that it eliminated trial by ambush, which they really liked. They used to, not give the other side the information about what was going to happen, and they could ambush them at trial. The rules of civil procedure, when adopted, were designed to eliminate that, and so that both sides are entitled to have all information that's going to be introduced at the final hearing in the case. So there's no, unless there's privileged information, and that's very limited, it would be required to be divulged as to all of the information that's been requested. So do you want to have anything to say about why some of these answers were not provided?
Your Honor, I responded in good faith and provided substantial information in my responses. And to the extent that there are specific deficiencies, I do remain willing to supplement appropriate requests. However, there were several requests that raised privacy, overbreadth, and proportionality concerns.
And you want to point to me, number one, what I'm going to do is I'm going to order that you supplement your answers within a certain period of time, within 30 days that you file a supplement to your answers to discovery. And under the rules, you either answer them, or if you believe it's not appropriate, then you can file an objection to it, but you cannot just simply fail to answer it. So within the next 30 days, what I'm going to put in order down here is that you supplement your answer and you fully answer all of the questions. Any question that you believe is objectionable, then you have to file an objection stating with particularity and specificity what it is that you object to under the rules of civil procedure.
Yes, sir.
Just let me add that first one I mentioned was that. The second, I'll just kind of go over, but and I know you just said basically do all of them, but the next was that we asked for a earnings record by the Social Security Administration, that she provide that shows her past income. She didn't do that. Also, we're asking for statements of her checking, savings, money market account, and only since the date of the divorce. So it only goes back to 2020.
And why would that information be relevant?
Well, it's going to, as far as child support, that's going to be an issue, whether or not she has other income. And the same thing as far as Venmo, PayPal, Amazon, I just need to know what her income level is. That's why that would be appropriate. And as far as Social Security, I need to know whether or not she's underemployed, overemployed, whatever. But again, for for child support issues, that we do that. And then I asked for a driver's license on number 16, and I asked for photographs of her home, including the outside the yard and the interior room. And the reason I'm doing that is because this is a custody case, and I want to know to make sure that there's she has appropriate place for the children to live. So those are the ones that, and let me say this too, Your Honor, when she sent her interrogatories, I sent her a deficiency letter back some time ago outlining that, but I'm going to put that in the order also that she has 30 days to answer that.
All right. Interrogatory number 9 was, interrogatory number 20 says, please state with specificity all complaints and allegations of which you intend to rely upon as grounds, listing specific incidents of misconduct by the father, and state the names and addresses of all persons who have witnessed and or have knowledge of any of the incidents you have listed. And then your response, Ms. Huey, was the responding party objects to this interrogatory to the extent it seeks an exhaustive catalog of all allegations, incidents, and potential witnesses, as such request is overly broad, unduly burdensome, and not proportional to the needs of the case. What you would need to understand is that he has a right to know anything that you're going to try to rely upon when you get to court. So if you intend to rely upon any type of information or incident involving Mr. Huey, you must divulge that and answer this question fully. If you do not, then when you come to court and you attempt to get into something that was not supplied to in your answer to interrogatory, then the court will be, if he objects, then the court will be forced to exclude that information. Do you understand that?
Okay.
All right. So to the extent that number 20 My ruling is that she will have 30 days to supplement that answer
Be glad to.
with those instructions.
Thank you.
There's a question number 3. Provide a copy of your earnings record as provided by the Social Security Administration, and a copy may be obtained from the Social Security Administration. You have objected to that as cumulative, overly broad, and not proportional to the needs of this case, not reasonably calculated to lead to discovery. You want to answer or supplement your answer or objections on that?
Yes, sir. So my understanding is, and from what Mr. Belcher just stated, that it was from the point of divorce forward, and I have supplied my tax returns, and I'm not understanding why that is not adequate.
When was this divorce?
2024.
Okay, so you want her entire
I do,
Social
just to
Security?
see.
Just let me finish talking.
I'm sorry, Judge. I'm sorry.
Do you want her entire Social Security Administration list of earnings back to the date she first got a job?
Well, I don't need that. I need the last 5 years. I just want to make sure that what she was making is what she is making. So basically, just to make sure that she's not.
When she was divorced, excuse me for interrupting you.
Yeah, no, that's okay.
When they were divorced, was there a calculation of child support?
There was.
Right, then they're bound by that calculation of child support and the showing of her income, absent some showing of fraud. So my ruling will be she's required to prove what her income is from the date of the divorce forward.
That's fine.
She says she has supplied copies of her income taxes, and that would seem to me for the years following the divorce, and that's all I'm going to require to provide.
With all due respect, Judge, the only thing I would ask is just copies of statements checking, just to make sure that everything is listed on her taxes are also.
Well, we haven't got to that one. That one is next one, right?
Fair enough, yes.
So as to the one that says that you're requesting a copy of your earnings record, I'm not going to require you to do that, but a copy of your actual tax return form since 2024, the divorce, will need to be supplied to Mr. Belcher, and we'll go from there. The next question is copies of your statements for your checking savings in retirement accounts, which you've had an interest since June 17th. You objected to that. You provided statements but redacted transaction descriptions for deposits and withdrawals, which may be relevant. You want to be heard on that?
Yes, sir. I redacted transactions. I did not redact any withdrawals or deposits. I left all of that visible. I left all of the large transactions, for example, mortgage payments and things like that. All of that has been visible. I only redacted daily transactions that seemed overreaching, and I didn't understand why those were pertinent to the case.
Mr. Belcher?
Judge, when we look at these statements, there's a lot of things that you could find. If she goes to the liquor store 3 times a day, that might be relevant. I don't know. It might be that she's spending, if she's going on big trips. There's lots of things that potentially could be discoverable, and that's the reason why we asked for
Ms. Yancey, Ms. Huey, I'm going to order that you have to provide an unredacted copy, but it will be filed with Mr. Belcher under a protective order of this court that it's not to be used for any purpose other than for preparation for trial. And so if he obtains an unredacted copy, he is to hold that in his file under this protective order. And that's the best I can do. He is correct. We have cases that people are using their accounts for transactions to purchase liquor at liquor stores on a repeated basis right before a visitation takes place, or that there are other expenses that are inappropriate. So the transaction record can be relevant, but the best I can do is order that it be provided unredacted and that it be held by Mr. Belcher under this protective order.
And Your Honor, is that just, are we looking at, bank statements?
What he's asked for is a copy of your checking, savings, and money market or investment or retirement accounts of which you've had an interest. This is all about your income. And what he's looking to see is if there are some people who try to hide their extra income, that they make a representation that they make only, this amount of money, but that their bank account records show that there is a substantial greater amount that is being deposited into the account, or that they're spending substantially greater amounts of money than their income would justify. And that's the reason that this becomes relevant.
And okay, yes, sir. So to be clear, only my bank account, my checking account, savings account, or retirement account is what we're talking about. Is that correct?
That is in number 8 of the request that says, please provide copies of your statements. If you refer to Mr. Belcher's number 8 on his interrogatories or request for production of documents, please provide copies of statements for your checking, savings, money market, investment, and/or retirement accounts in which you've had an interest since June 17th of 2024.
Yes,
So
sir.
that's the question that I'm ordering. You have to file unredacted copies, and then that will be filed with them under a protective order. The same thing goes for number 9, which is copies of Venmo, PayPal, Amazon, Zelle. I don't even know what Zelle is, Zelly, Cash App, or other such accounts that you might have. And again, it's the same principle, that they're looking for any indication that you're actually have a greater income than what you are representing. And not to say that will be the case, but they have a right to see those unredacted. So number 8 and number 9, you'll have 30 days to provide that information. It will be provided under this order, which provides that information will be filed under seal to Mr. Belcher, and he will not be able to use or disseminate that information beyond trial preparations.
May I ask one more clarifying question?
All right?
Regarding number 9, where there's Venmo, PayPal, Zelle, things like that, are all of the because a lot of those are person-to-person transactions, may I redact the names, or do the names need to be included as well?
Any reason why, if you're looking for the income information, there's really no reason the names would have to be at this point. Let me say this, we're going to allow you to redact the names if Mr. Belcher later determines that a particular transaction is one he needs to follow up on, then he can apply to the court to have that name unsealed.
Yes, sir.
All right. Number 16, a copy of your driver's license.
And Judge, I provided a copy of my driver's license. The only thing that I redacted was my driver's license number.
Skip.
Number 21, provide photographs of your home, including the outside, the yard, and each interior room, including bedrooms and bathrooms. Now, you have any objection to providing those?
Your Honor, I guess I just didn't understand the reason my ex-husband has been here several times, has been invited to come in and has declined. So I didn't understand, especially in those circumstances, how that was pertinent information and what could be gained from that.
Where your children or child is going to be residing, and where do you, you don't have to tell me the address, but where are you?
Mount Juliet.
Okay. Where you are residing with your minor child does become an issue for the court to determine if the environment that you're providing is appropriate. And all I'm understanding he's asking is for you to provide copies of the photographs of the interior of your home, which normally you would do when you come into court to show that it's a good place for your son to live. So I'm going to order that you do that. It's a little bit unusual to require you to make photographs, but I can't require her to produce photographs if she doesn't have them. I can't make her go out and take photographs.
Well, let me say this in the alternative, I guess, if your court could order a time maybe for us to go out and I could take the photographs.
So you want to take them?
I don't want
Mr. Belcher to take them?
But
I guess, honestly, Judge, it feels very invasive and intrusive.
why I asked it.
Especially when the father's been invited in before and has declined to be, he's specifically been invited to see it, come inspect, come see where your son lives, and has declined. There are photos of the apartment complex online.
The idea that it is invasive and intrusive is correct. And unfortunately, when two people come before the court and I don't know either one of you. So I don't know anything about your house. I haven't been invited to your house. And if I or one of the other judges have to make the decision, then having the most amount of information, the greatest amount of information about the conditions, the circumstances, what it looks like. As I've said, most of the time, the person who's seeking to have the child live in that home brings photographs before the court to show this is a great environment. Here's his room. Here's what it looks like, to satisfy the judge that the child will be living in an appropriate environment. I am not going to order that she has to provide those photographs. She can either produce them or not. That's up to her. But I will say that obviously the judge who hears this case is going to want to know what kind of environment it is. And if she doesn't provide them, then Mr. Belcher, you and your client can argue to that judge or to me that her failure to provide copies of photographs that show what the environment was like may be an indication that there's an inappropriate environment.
Let me ask you, Judge, if she provides, though, can she at least, I mean, if she does take pictures and she intends to show those, will she provide those to me ahead of
If you intend to
trial?
take photographs and show them at court, you have to provide a copy to Mr. Belcher. If you do not, then that's your choice. But I'm not going to require her to go out and take photographs of her own home and then mail them to you. So if she's going to take them and use them at trial, then she has to provide them to you.
Okay.
All right, that concludes the discovery issues, if I understand correctly. You've already dealt with your motion to dismiss the amended petition, which she can do. You have a motion to change venue.
Judge, the only reason I say that is the children are now, are residents of Wilson County. They've lived there for more than 6 months. The mother now is in Wilson County.
Where's your client?
My client still lives here, but I'm out of Wilson County. So it's not a big deal. Listen, it was a very pleasant drive, but it did take an hour and a half to get from Mount Juliet to here. It was very nice this morning, but that's the reason why I'm asking that. It's just for basically convenience sake for the mother, the children, me. But let me say this, if she wants to have it here, I'm
Ms.
okay.
Huey, I don't care where this case is
And I don't
heard. And if you want to have it heard in Wilson County, since you live there, then that's where the child is. That's where the court that would have the greatest opportunity to hear it. I'll be glad to change the venue to Wilson County. Do you want it changed to Wilson County?
Well, so my concern is avoiding prejudicing the matters that are already pending before the court, and particularly the unresolved financial issues, the custodial account issues that arose while this was before the court. And my older son has now reached the age of majority. So I'm just concerned about moving it extending the times, additional costs and things like that.
You know, I think it would be less cost if it was done in Wilson County because everybody's there. Almost everybody's there except for the father and the father.
Normally it's the person who doesn't live in Wilson County who is objecting to it. I don't care. If you object to it being moved to Wilson County, we'll leave it here. If you want it moved to Wilson County, it should not make any difference. All that happens is that all of the pleadings that are here get transferred over under a court order to Wilson County Chancery Court.
Your Honor, I object to moving. I would like to keep it in Dixon County.
Remain here.
It'll stay here.
There's a motion to compel mediation. We have a local rule that requires mediation, so the parties will be required to undergo mediation until at some point before the final hearing.
So the only reason I filed that is after the discovery, the first set of discovery was submitted, I had asked to set mediation up, and she refused and said that only until we provided a 408 proposal would she even consider mediation. And I don't see that as a barrier to, and I have an email that states that. But either way, Your Honor, we'll set mediation ASAP.
And lastly, there's a motion to dismiss the plaintiff's petition to modify child support. And obviously, the issue of child support is one of those things that, in my opinion, needs to be heard at the final hearing.
The only reason I put that in there, Judge, is in her petition, she was asking that it be retroactive to the date of divorce.
So that'll be for argument at the final hearing. You cannot get a retroactive modification of child support when there's a court order down, other than the fact that you could get it from the date of filing a petition to modify. In other words, you've got a court order down that sets child support. That is controlling until you file a petition to modify. Once you file a petition to modify, if it takes 6 months or a year or 2 years to get it heard, the retroactive modification can be to the point where you filed your petition to modify. But you
Yes, sir.
can't go from the petition to modify back to the date of the actual divorce, because that's a res judicata is the term we use to determine that.
Yes,
All
sir.
right.
And I amended my petition.
Mr. Belcher, would you draw an order, please, reflecting all of my rulings, and then submit that to Ms. Huey?
I will. Judge, thank you.
All right, thank you, Ms. Huey. You may leave our hearings. Good morning.
Judge, we've got a few matters. Nicholas Bellamy, the Montgomery County Bar, Your Honor, representing Michael Thomas. We've got a few motions pending before the court this morning. We have resolved a few by agreement. We should probably start with those. The motion to compel discovery filed by Mrs. Thomas, we have agreed we will enter an agreed order requiring Mr. Thomas to complete those discovery responses within 14 days of today, Your Honor.
All right.
With respect to Mrs. Thomas's motion for contempt regarding the alimony payment, the May alimony payment or support payment, temporary support and child support payment, were paid today. Are you reserving issue?
Also, the auto insurance that was cut off will be cut back on today.
That is correct.
And then there's a health insurance issue that will be reserved for final hearing.
All right.
So that takes care of the motion to compel discovery and the motion for contempt. By my count, that leaves Mr. Thomas's motion to reduce support, motion to review DNA testing, and then his emergency motion for immediate return of the minor children. That kind of complicates everything. I anticipate, depending if the court's able to take up a hearing today, I do anticipate having a contested hearing on that motion.
All right, well, let me run through, I would expect that will take some time. Let me run through the remaining cases and see where we are, and I'll come back to you.
Very well. Thank you, Judge.
All right.
Taking time, I filed a motion for Mr. Bates to be arraigned and for a trial date to be set.
All right. So Mr. Himmelberg is here to represent him on the criminal contempt, is that correct?
Actually, Judge, it'll be Bo Yeager.
Mr. Yeager? You still represent him on the civil matters?
I'll respond to that. We're asking that be dismissed. We're going to take argument on that.
All right. Then let's arraign Mr. Bates on the criminal contempt. You wish a formal reading of that allegation?
No, Judge.
Plea of not guilty will be entered. Do you want to set it for a hearing then?
Yes, Your Honor, we can, if you got Mr. Yeager's calendar, do I need to just correspond with him and give like
No, we.
available dates?
Well, does it necessarily have to be heard in front? I guess it should be heard in front of me. I've
Well,
given
Your
out-
Honor, the allegation is dealing with testimony that happened in front of you during the hearing.
All right. June 15th or 16th? You have the 16th.
Your Honor, I'm here on a final hearing, McNeil versus McNeil, in front of Judge Wallace
On the 16th?
on the 16th. And then on the 15th, Ms. Duke and I have a matter already set in Humphreys Juvenile, McBride versus McBride.
Okay.
Apologize, neither one of those dates.
Well, I have the 26th of May. I don't know what that looks like.
Well, Your Honor, you have a Tyson versus Tyson competing orders, a final order in Mangrum, final hearing in Mangrum, and the hearing, I don't know what it was, King versus Oliva. That's just me. I know there's,
And then the Marlin case, you said, is that going to take most of the day? On the 29th of May?
Your Honor, I don't think it will take most of the day. That would be fine to set it if he's available on the 29th. It's a contempt and a modification of alimony, spousal support. That's the one where they tragically lost one of their children. That was just that was an appearance, that was just a,
The
Mr.
29th?
Bates has reached out to me to ask to continue Marlin.
May 29th?
All right. Bates, motion for contempt.
Thank you, Your Honor.
Thank you, Judge.
You may. Pardon?
It was served on him, and he accepted service, and I can show you, I can email you another petition, but he accepted service on it. Yes, sir.
Thank you, Judge.
You're welcome.
Okay, then, Your Honor, the only other motion that's on the docket for today is my motion for Your Honor to consider attorney's fees. Your Honor will recall, we tried this matter over a series of 5 days, starting in August of '24 and finally ending in August of '25. And during that period of time, we were able to reach after testimony, we were able to reach an agreement on property division. And then we proceeded on the issue of adoption of a parenting plan. Both parties had requested attorney's fees. Your Honor took it under advisement after the August hearing and then issued your order in September. And what we are asking, Your Honor, is we have filed a motion requesting that the court assign attorney's fees and extraordinary fees, particularly the guardian ad litem fee, and also a mediator's fee. Your Honor will recall, I'm not going to belabor the point, so I'm doing it. I would first request that if the court considers an award of attorney's fees, that I be allowed to submit my hourly billing, and Your Honor determine which portion would be attributable, particularly on the mediator's fee. Your Honor, you recall we went to mediation one time. We came back to court. This was when Mr. Bates was represented by Mr. Potter.
That's where he fired Mr. Potter?
In the middle of mediation, he fired Mr. Potter. We went back to try to resolve the mediation. We tried to resolve the property issues, and so we incurred an additional mediator's fee and time at that. And Mr. Bates became disheartened with Mr. Potter and because of certain issues that he fired Mr. Potter, and so that mediation should necessarily be attributable to him. Your Honor will recall that this matter originated with Mr. Bates with the criminal matter. He started out supervised visitation. We went through counselors. We came to court on, I believe, 5 different occasions for the court to expand his visitation with the children. And as a result, he pled guilty on the domestic assault. He completed a anger management. He did that. Those charges, based on the agreement with my client, were expunged from his record. And again, it's a scenario where there is an alimony award. In this case, obviously, he has a significant higher earning capacity. And Your Honor, the underlying criminal contempt matter that we've just arraigned him on, you will recall that Mr. Bates, during the pendency of this case, was supposed to deposit funds into the account. He was supposed to account for all his business dealings. And lo and behold, we find out that Mr. Bates created a secret account and paid cash for a piece of property, which he purchased in his own name. He testified that he expended an exorbitant amount of funds to remodel and to build a home, to do things on that property during the pendency, all without the court permission. Those were not disclosed in discovery. That was all testified to at the hearing. And again, it's just our request, Your Honor, that Your Honor consider an award of attorney's fees on behalf of my client. I was handed today, right before Your Honor took the bench, a response that apparently was filed this morning. And again, the sum and substance of the recitation of facts is, Ms. Anderson said it's correct that attorney's fees in divorce cases are considered as spousal support and considered as an alimony award. And again, as she sets forth in her response, the factors set forth the total amount of the attorney's fees and whether the attorney's fees are reasonable, and were they necessary. Again, Your Honor, will recall, we took up the better part. This case originated in 2022, and we took up virtually every time Your Honor was on the bench from 22 through 25. This case was on Your Honor's docket at each month that you were in Dixon County on these issues. And we would request that Your Honor allow me to submit my affidavit of fees and extraordinary expenses, and you consider an award.
Ms. Anderson?
Your Honor, I had filed a response. I wasn't sure if you had a copy of it.
I just looked at it in the file. I had not seen it until a moment ago.
I filed this response requesting that the motion for attorney fees be dismissed. I believe that the motion that's been filed is untimely. We had a trial where there's an order that said we were supposed to pursue attorney fees at trial. It's in an order signed by Your Honor. There was no evidence presented at the trial. Ms. Bates had the opportunity to ask for attorney fees while we were here. As Ms. Roberts had said, we were here for 5 days. I know they all weren't full days. A couple times people had gotten sick or whatever. But we were here for 5 days, and she never once brought that issue before the court. It's now been almost a year since the party's last hearing date. I would direct Your Honor's attention to the order that you signed on September 15th. We had completed about 2.5 days of trial, and we had settled the entire case with respect to alimony, property division, primary residential parent. Everything was settled. That you signed that on September 15th, 2025. And in that order, we agreed, we announced it in open court. Mr. Bates agreed that the mother, Ms. Bates, was going to be the primary residential parent, and the only issue that was left was the residential schedule, like decision-making, who was going to get tax deduction, things like that. And in that order, it says that each party reserves the right to request attorney fees at that time. We knew we were coming back on July 31, 2025 for the next hearing date. And we came back on that day, July 31, 2025. There was no evidence presented. We needed a few more hours of trial time, and we came back on August 15th, and we finished up the case that morning, and there was no evidence presented during that whole entire proceeding. So I believe that this request for attorney fees now is untimely. They had the opportunity to present this during the trial, and they sat on the rights and didn't do it. You've already signed an order dated September 15th, 2025, telling the parties if they want attorney fees, bring it to Your Honor's attention on July 31, 2025, which they did not. It's been over a year since that was filed. And I know that, it is in your discretion that you may award attorney fees. There's actually a statute on that. It's under 36-5-103. It talks about attorney fee awards, that they may be awarded, that Your Honor has discretion. But if you look at Section C of that, it talks about a prevailing party. And a prevailing party in a contempt issue, in an enforcement issue, and if you want to alter parenting time, if you want to change custody. No, we'd already determined that the mother's going to have custody. So the issue that was left to be resolved on that last day and a half was just the father's parenting time and who gets the tax deduction and how much the child support was going to be. And the issue of the primary residential parent wasn't even on the table. So I'm just asking that this request for attorney fees be dismissed, because Mr. Bates should have an opportunity, if you're going to open this back up again, to look through this so that he can object to it, and he also asked for his attorney fees. And I would just point out that some of the issues that were left that last day and a half, he got what he asked for. He got a tax deduction for one of the children. He got expanded parenting time on the weekends. He got more time in the summer. The mother only wanted him to have 1 week in the summer. You gave him more time. So he had issues that were valid before the court. And I think that the issue now to bring up is completely inappropriate. On the other issue, the guardian ad litem fees, you can look back in the court's file. The guardian ad litem was appointed in March 2022. And there's just one sentence, it's paragraph 7, it's numbered 7, that Mickey Smith Esquire is appointed guardian ad litem for the party's minor children. Rule 40A wasn't followed. It should have said how much it was going to cost. It should have set her fee. It should have told them how much they were going to be putting into the clerk's office. And right before the final hearing, you're supposed to let the parties know how much this is going to be. So she did a great job, and she was in the case for 3 years. She sent us an affidavit in December, and it was, I may be making this up, it seemed like it was several $1,000s. So as soon as we got it, I had my client pay half. I said, just go ahead and pay half, and we tried negotiating, a settlement on that. But now, Ms. Bates doesn't want to pay her half. So I also believe this guardian ad litem issue has a little bit of problems, because the original order that appointed her did not talk about fees. It didn't follow the Supreme Court Rule 48, which is supposed to advise the parties what their financial burdens are going to be, but to surprise them years later with this huge bill saying you owe now this guardian thousands of dollars. It's completely unfair now and unjust for Mr. Bates to have to pay this. He did go ahead and pay half of it, and I'm just asking, if you look back at your file, the amount of assets that each of these parties were awarded, their marital estate was well over $1 million. Ms. Bates got half of that. She has the ability to pay this money to the guardian ad litem, and it would be extremely unfair now, 3 years, 4 years after her appointment, to have Mr. Bates have to pay all of it. And we're asking that you just order they pay it in half, and that you dismiss the attorney fees request now at this point. Thank you.
I would just end. Bates filed the provisions that he asked for. He was basically asking for a 50-50 residential schedule. Your Honor's hearing, again, on the order that we entered on September 15th of 2025, it specifically reserved parties' right to request attorney's fees. There was testimony as to that she had retained me on the case and the hourly rate. Again, Your Honor took it under advisement. We did not know what was going to transpire from that. Your Honor then made in the order of September 5th, Your Honor made the specific statement on page 3 of 11. Since the parties are unable to agree, this court is required to provide a parenting plan set forth. I mean, Your Honor found they were not able to agree on anything. The stipulation at the beginning that she was the primary residential parent was done from the beginning, but argued that he should have equal time. Based on the court's prior evidentiary hearings and the testimony of the therapist, Ms. Pate and Ms. Morton, and the recommendation of the guardian ad litem, the court's own observation of the parties' demeanor and credibility, the court finds that an equal residential schedule would not be in the children's best interest. So we were arguing over substantive matters, Your Honor. It's to come in and say, oh, we stipulated one part of a parenting plan, and therefore there was nothing to litigate. But the devil is in the details, as Your Honor knows. We litigated every aspect of that parenting plan. The final decree did. Mrs. Kelly Jo Bates is awarded an absolute divorce on the grounds of cruel and inhumane treatment, also known as inappropriate marital conduct. And again, that was the request that was made. She was victorious in getting the divorce. She was victorious in getting named as the primary residential parent and had to defend vigorously the schedule that the court finally adopted. So again, Your Honor, and as far as the attorneys, as far as the guardian ad litem fees are concerned, they were reasonable and necessary. I can provide the court a transcript if necessary about the appointment. It was my understanding at the time, and again, I didn't pull that because again, I did not, even though this motion for attorney's fees has been filed since December, I did not receive Ms. Anderson's response until right before Your Honor took the bench, and on the appointment of the guardian ad litem. It was my understanding, and again, my thing is that Mr. Potter, his attorney at the time, stipulated and agreed that would be appropriate. And so, again, I'll have to go back and review the transcript on that. So I don't have an independent recollection. I do recall during the pendency of this that they continue to file motions to expand his residential time.
Basically, I understand Ms. Anderson, but at the time that the guardian ad litem was appointed, both parties were in agreement with it, and there was no objection made by Mr. Bates's lawyer at that time. In fact, I think both parties were more than willing to allow Ms. Smith, who has long served as a guardian ad litem in these kinds of cases before this court, and her fee schedule was known to both Mr. Potter and Ms. Roberts. So this court is of the opinion that the guardian ad litem's fees were reasonable and should be approved. However, I do find that they should be split equally between the parties, and that Ms. Bates should pay her half because that was the agreement that was made at the time. It may not have been an agreement, but that's tacit in this court.
Yes, Your Honor. And again, I would say, Your Honor, that the evidence was clear at the court that Mr. Bates used the marital funds through the company Infinity Builders, and we produced checks at the hearing where I know at least one occasion he paid $25,000 to Mr. Potter using joint funds that my client did not have the benefit of. And then there was additional payments that were shown in the bank records that he paid Ms. Anderson through business funds. And so, again, it's a scenario where the entire lifestyle of Mr. Bates was funneled through, and he was able to pay his attorney's fees as they went. And he paid Mr. Potter and Ms. Anderson through marital funds, and that was through the business that he was supposed to be putting into the account. So Mr. Bates paid his attorneys, and
This evidence was never brought, which is when it should have been brought. And now here we are. Relevant statute goes back.
Well, I understand you're objecting, but let's let Ms. Roberts finish her argument, then I'll give you that opportunity.
Your Honor, it was brought up at trial. We submitted the documents, and I asked him particularly at trial. If Ms. Anderson doesn't recall that, but we did go through those documents and show
My
those.
recollection was that there was an issue about Mr. Bates using the corporate or the business accounts to pay personal, including some portion of his attorney's fees. Now, Ms. Anderson, if you want to address what you were saying.
This motion was brought under Rule 54. Rule 54 has nothing to do with attorney fees. That can do discretionary costs, guardian ad litem fees. This is a totally separate issue. This is under 365101H. If you're going to look at an attorney fee award, you have to look at the factors enumerated. So you have to look at the total fees incurred by both parties in the case. And you have to go through all these factors, which party has the ability to pay them, whether they're reasonable. We have to have a trial over all of this. And I've never even seen the affidavit, so I don't even.
She hasn't submitted an affidavit.
I know. It seems like if you would have filed it in December, you would have sent us something, but I haven't seen anything, so.
If I understood Ms. Roberts, her motion is to be allowed to file an affidavit, which she has not yet done, so
Well, I thought her motion said just she wants to be awarded attorney fees, just like that, under Rule 54, which isn't the right rule. So, you know, I also feel like this issue has already been put in the court's order. You already spoke to this. They were supposed to bring this to the final hearing. You signed it in September saying, if you want to bring this issue of attorney fees, bring it up at the final hearing, and they did not do that. We were here all day on July 15th, and then we came back in August. They did not do that. They left the building and sat on that. And then they waited until December and said, oh, we need our attorney fees, and they filed a motion under Rule 54, never sent an affidavit for us to even look at, and here we are 5 or 6 months later for something that should have been done a year ago. And I'm just asking that if you found that it's untimely and that they didn't file it during the hearing and that it needs to be dismissed.
All right, your motion to dismiss is currently going to be overruled by the court to the extent that I'm going to allow both sides, if you choose, to submit your affidavit of attorney's fees. I will take this matter under advisement to be able, because of the multi-days that I had to deal with this case in trial, it is not, and that's been some time, is not as fresh as what I would like to be able to rule on this. I need to review the file and my notes. So we'll take it under advisement. Both sides have 30 days to file any affidavit of attorney's fees that they wish to. I've already ruled on the guardian ad litem fee. All right.
If I could. Your Honor, we filed this motion, this petition. It's a petition to establish paternity and to adopt a parenting plan. And it is, their urgency has created itself in this matter as the parties have 2 minor children. And I believe the eldest will be 6 on the 22nd of this month, as well as the youngest has the same date of birth and will be 4 on the 22nd of this month. The parties were residents of Dixon County. They have had
Both children share the same day of birthday?
They have had shared parenting of these children. The parties resided together for a number of years, a total of 7 years. They split up in a couple of 3 years ago, I think 2023. They split up and they've had an equal residential schedule since that time. During that period of time, the mother has had some significant issues with drugs and different things that have gone on. But the parties were working well together as far as sharing the children on basically a 50-50 residential schedule. Unbeknownst to my client, Mrs. Mowell, the defendant in this case, packed the children up and moved without notice, without anything. So again, it begs the question of the parental relocation statute, because again, the parental relocation statute, you can interpret it in a number of different ways. There's not been a finding of, my client never went forward and established paternity, and the parties never married. But he is listed on the birth certificate, and he was spending intervals of time with the children and basically had an equal residential schedule. And Mrs. Mowell just packed up and moved with her now paramour to Illinois with the children. What has happened is that my client actually came in prior to the move and was thinking about filing this, and then it became an emergent situation when she packed up and moved. My client did go up and had arranged with her to visit with the children. He went up and picked up the children, and lo and behold, she got served a couple of hours after he picked up the children, and she called and threatened to have him arrested for kidnapping if he did not bring the children back immediately. So we're here ready to go forward on a temporary adoption of a parenting plan. I do not think, I will have Ms. Mowell address it, I do not think paternity is.
She said the discovery requests were too invasive, but the judge shut that argument down during a heated custody battle packed with accusations, financial disputes, and courtroom tension. The hearing exploded after a mother objected to turning over unredacted bank records, Venmo transactions, and other personal financial information during an ongoing parenting case. The judge explained that when parents fight over custody and child support, the court has the right to examine whether someone is hiding income or living beyond what they claim in court. Things got especially tense when the mother argued that requests for photographs of her home felt very invasive and intrusive. But the judge fired back with a blunt reality check. That is correct. Then came the strongest moment of the hearing. The judge explained that once parents bring a custody fight into court, private life stops being completely private, because judges must know what kind of environment a child is actually living in. He warned that if she refused to provide information about the home, the other side could argue she was hiding an inappropriate environment from the court. The courtroom stayed tense as the judge ordered unredacted financial records to be turned over under a protective order, while repeatedly reminding both sides that family court is not trial by ambush. Do you think courts should have access to this much personal information in custody cases?
All right, let's run through the remainders and we'll come back to the hearings on these motions. 2022 CR 340 State versus Bryce Malik Jones, Mr. Atchison.
Otherwise known as the ping pong ball judge. Mr. Jones was in Texas. He is now in the state of Missouri, trying to get that facility there to coordinate with us here to allow him to at least be on the TV there, but have not been able to do so yet. General Wojnarowski's case, she's well aware of our troubles that we've had with Mr. Jones. Judge, I think we just need another status date until we can get him here. He's got a couple of sentences running. One's federal, one's state of Texas.
September 23rd.
September 23rd. Thank you, Judge.
2009 CR 258 State versus Tommy E. Jones. Tommy E. Jones on a writ of habeas corpus. He's been released. All right, he's been released. His motion for writ of habeas corpus is declared to be moot and is dismissed. 2026 CR 39 State versus Chandler James Moon. Mr. Sergo, this was for attorney status. So do we need to set a status date for possible disposition?
Yes, if it pleases the court, this is the first appearance on my part, and I do have discovery for the state, which I'll turn over before I leave today.
September 23rd will be your next status date. Yes? Strike what I just said. Plea date, this is in front of a different judge. The plea date is July what? 17th, and trial date? July 24th for trial. All right, that's Judge Lockhart Mash, so you'll need to be here on July 17th and have your case disposed of or go to trial on the 24th.
Thank you, Your Honor. I believe that does complete my business before your
Thank
court.
you.
May I please be excused? Thank you, sir.
All right. 2024 CR 107 State versus Kenneth Ray Ogg. Do we have it, Humphrey County? We've already done Humphrey County, haven't we? We bringing out Mr. Ogg. Kenneth Ray Ogg is coming out. Okay. While we're waiting on Mr. Ogg, 2022 CR 91 State versus Timothy James Osgood. That's Ms. Coffenberry's case. Anyone heard from Ms. Coffenberry this morning? set.
Judge, Ms. Coffenberry and I have been in discussions about this case. She has a family member with some medical needs and asked me to just get a new status date. So if we could set it September 23rd.
Mr. Osgood, your lawyer has been talking with the district attorney, and she has asked that we reset your case for September the 23rd for status to let her try to continue to work out something if possible, okay? We'll see you on September 23rd.
Thank you, Your Honor.
Thank you. Sierra 158 State versus Deandra Rashad Portis. Mr. Flanagan. All right, well, let me deal with Mr. Ogg while I was trying to multitask here. 2024 Sierra 107 State versus Kenneth Ray Ogg, probation violation.
Your Honor, I'm stepping up to the podium. I think that my office may have already, can I stand here? Thank you. Has already been appointed, I think, Your Honor, or this may be an arraignment today. I'm not exactly sure exactly. Thank you, Madam Clerk. This is, oh, sure. I've got this case set for a status on Your Honor's docket. His new charges, not this case, but his new charges on September 8th. I thought if we could put this on the same date. that'd
All
make a
right,
lot of
September
sense.
8th.
Thank you, Your Honor. I'm going to come talk to you.
Now we'll go back to Mr. Portis. What were you trying to say, Mr. Flanagan and Mr.?
Patrick Thompson, 2022 CR. Thompson is present in the courtroom, he's been present every time.
My client is not present this time, but he's in Birmingham. He can get on by Zoom if we need him to. Judge, and part of the problem was there was a potential conflict in my representation. I won't mention any names, but I also represent one of the witnesses in the criminal case. But if this trial is set beyond September 1st, I think that conflict will go away. If it doesn't, he's got a lawyer in Birmingham who will make an appearance pro hoc vice and come up here and try the case along with me, and he would cross-examine that witness. So I think we're okay.
Well, I have September here in Dixon County, but I think that pretty much is full for trials, is it not? So we're looking at January for a trial date.
That'll resolve my conflicts if it would go to that.
What about January the 8th? If I'm setting a trial date, I'm giving you a date that was otherwise open, so I need you to commit to the fact this is actually going to go to trial, because I don't want to waste an open day. Is it a day-long, one-day trial?
2.5 to 3.
Two and a half to 3? General, is that what you think?
Just going by the discovery.
Well, we have, go ahead, what is it? Well, we've already filled up the criminal docket for January on trial dates already with cases that are multi-day cases. We have the daycare case out of Stewart County, that's the 20th through the 22nd. Then we have the 28th through the 29th, are the State versus Eric and Toby Aldridge. That's your case, is it, Mr. Waynick? We have other days, but they're single days. All right, we can do that. We do have marked that February 1st is available if necessary for the trial. All right, so we're going to put Portis, and your client's name is Thompson.
Yes, Judge.
Is he on the docket today?
He is.
What page? All right, Patrick Wayne Thompson.
Can we set him on a status date?
Do you want a status date or do you want a trial date? Because if you're setting a trial date, it's going to trial. You want a status date on September the 8th?
I would ask for a status date.
They'd have any opposition to setting one more status date?
Reason why is we've been talking about so we still have to file.
Well, this is exactly what I was saying. I don't want to put it on the trial docket unless it's actually going to trial. So September the 8th. And that will be for Mr. Portis as well?
Yes, Judge.
All right, September 8th.
Thank you. And I will have him here in person on that.
Okay. You had, I think, another case that I called while you were out, doing whatever you had to do before you got here. Let's see if I can go back to it.
My daughter had car trouble. The way I handle that is I call somebody else.
I think that was a wise policy. Corey Poteet, and it was to set a trial date. He came in on Zoom.
And he's the co-defendant to Ms. Condor, who has a motion today.
We'll check and call.
Yes.
Han says he's getting probation over there, but it's consecutive.
Okay, I think I am at page 11, 2026 CR4, State versus Mark Edwin Seaborn. Does he have a lawyer?
Judge. Atchison stood up.
Who signed that order? It's a classic example of no good deed goes unpunished, so. And we bringing out Mr. Seaborn. Does the public defender's office have a conflict, Ms. Rhonda, that you know of, Mr.? He was trying to hire someone, but I don't think he's been successful. I just want to know what my options are when we get
Yes,
started.
I'm not aware of any conflict, Your Honor.
All right, you are Mark Edwin Seaborn, is that correct?
Yes, sir.
Mr. Seaborn, you're charged here in a multi-count indictment with rape, incest, statutory rape by an authority figure, especially aggravated sexual exploitation of a minor, solicitation of a minor for rape, and solicitation of a minor for especially aggravated sexual exploitation of a minor. Previously, we had indicated that you had a lawyer or that you were going to hire a lawyer, but that's not been consummated, is that correct?
That's correct.
Are you able to hire a lawyer, or do I need to appoint the public defender's office to represent you?
I need an attorney, Your Honor.
You need someone appointed?
Yes, sir.
All right, I'm going to appoint the public defender to represent you on these charges. Mr. Talbot's here with the public defender.
Yes, Your Honor.
We'll show that I think he's already been arraigned, so we'll show that you are the lawyer. And are we setting a status day in September, General? Or does it have a date? This was his status day, so we'll need to set a status. I would suggest September the 23rd.
Yes, sir.
All right, September 23rd. That's the day to let your lawyer get familiar with your case, discuss it with you, and get the discovery. necessary so that we can decide whether or not you're going to try to resolve it by an agreement or we need to set you a trial date, okay? All right, thank you. 2017 CR 226 Day versus Caruana Tishan Strickland. Is that microphone at the podium on? This is here for review of payments, if I understand correctly.
Yes, sir. Yes, sir. Yes, ma'am, sorry.
And who is the other judge? All right, you are set up on a payment schedule, and this is to review and make sure that you're making payments. So we're going to put you in January of 2027 to make sure that you got to make the payments. If
Yes,
not,
sir.
then they're going to bring you right back in front of a different judge, okay?
Yes.
All right, January 8th, was that the day that I think we have? Let's put it on VOP Day in January, which... January 27th. We're going to give you till January 27th, so you ought to be able to resolve this by
Yes,
then, okay?
Can I ask you a question, Judge? I think I might know your daughter. Is her name Rebecca?
Is her name what?
Rebecca?
No.
Oh, okay, I'm sorry. Okay, thank you.
Close. Thank you. All right. 2024 CR 98 State versus Joanna Lynn Swiger. Mr. Wainick, this is part of the motions. All right. Got an agreed order what?
To continue the case. I don't know if he wants to argue the motions or if he wants to pass them at this point.
Well, my inclination is, I've got a number of motions in this case and another that are going to, apparently I'm told is going to require considerable amount of time to go through. I don't care whether we set these motions, if you're continuing the case by an agreement. Mr. Wainick, what do you want to do about your motions?
I didn't put a date on them anyway, so I don't know how they got on today's docket. And then if we need to hear them, I'll file a notice for hearing.
All right.
Thank you, Judge.
All right. Then we also have 2023 CR 229 State versus Erica Ann Tidwell Davenport, and those are a number of motions as well. We'll come back to that. In 2022 CR 336 State versus Sherrick Markey Vaughn has an original amended motion for new trial. And then on 2024 CR 142, also a motion for new trial. Okay. All right, this is the State versus Sherrick, Markey Vaughn. Mr. Vaughn, in docket number 2022 CR 336, in which you were convicted by trial by jury, and you were convicted for retaliation for past action, sentenced to, I believe it was 6 years in Tennessee Department of Corrections. You have filed a motion for new trial, as well as a motion for new trial in your case, docket number 2024 CR 142, which was failure to appear. So today is the hearing date for your motion for new trial in both of those cases. Are you ready to proceed on that?
Your Honor, I have more motions filed than that. I have also a motion for acquittal. And if it could, can I get a copy of those motions? Because I got transferred to TDOC and all my records has been destroyed. I have not a copy of none of this stuff.
I can have the clerk run a copy of your motions and give it to you, but will mean that we'll have to come back to you a little later in the
That's fine.
day. So. All right. If you will please run a copy of the motions, and then we will come back to Mr. Vaughn.
Judge, I have a copy of the motion for new trial and the amended motion for new trial. I'm looking to see, I may not have the additional motions that he's referring to.
Yes, sir. There's a motion for acquittal, a motion of stay of judgment. There's a subpoena for the chiefs of the jail. There's a subpoena for Jennifer Dozier to testify today. And I got two more here. If you can have somebody come get them, I would like to add an amendment. You granted me amendment. I got this page, if you can tear it out.
We're going to have the clerk make a copy of all the motions that you filed, and General, you may want to look at those copies before we deliver them to him to make sure you have the same copies.
This page.
And we will come back to you. Just if you'll step back with the officers until after those copies are run, it'll be later in the day. I will need a copy of those as well, I guess, so if you'll have them run a couple of copies.
And Judge, I do see the request for subpoena. Were any subpoenas issued for today?
There's a request for a subpoena for Jennifer Dozier.
And, what's this captain's name, the chief? Jail administration, there was a requested here today too.
And how does that factor into your motion for new trial?
It factors in because I put in a motion for acquittal. It factors in because the chief from the jail can testify who has authority once someone enters into their facility, and Jennifer Dozier's testimony can testify to a sequestered witness.
All right. Well, have those subpoenas been served?
No, they haven't.
Then we'll necessarily have to reset your motions in order to get those subpoenas served, if that's what. So we will reset you for September the 23rd in order that those subpoenas be accomplished to serve on those individuals that he's requesting, and that they be brought in on September the 23rd for a hearing on these motions. All right, we'll see you September the 23rd, and those subpoenas that's ample time for those subpoenas to get served, so they should be served.
Okay. You should make sure I get a copy before I leave of all those two?
We'll give you a copy before you leave. So.
All right, thank you.
All right. 2024 CR 144, State versus Christopher Bryson. That is Mr. Lockhart's case. All right. Did we ever hear from Travis Jermaine Cole out of Perry County? All right.
Your Honor, there's one case that I can announce on from
All right.
earlier. Your Honor, that would be Derek Gordon's case, and that's
Okay.
going to be page 2, I believe, of the docket.
It's on page 5.
Excuse me, page 5, Your Honor.
2026 CR 71.
Yes, sir. And Mr. Gordon's case, he is set for status today, Your Honor. I've been advised that he's in court in DeKalb County today, and therefore that's why he's not here. May we please set this on the September 23 status date?
September 23rd for status.
Thank you, Your Honor.
All right, anybody have anything that we need to address before I take a short recess? When I come back, we'll take up this is going to result in 2 convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement?
Yes, sir.
Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer the questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
Then are you in fact guilty of these 2 drug possession charges?
Yes, sir.
You want to tell me what happened? What were you possessing?
Methamphetamine.
All right. General, do you want to supplement any facts on this?
Judge, if this case went to trial, the proof would be that on November the 8th of 2023, agents with the Drug Task Force made a traffic stop on I-40 here in Dixon County for speeding and following too closely. Mr. Bryson was the driver of the vehicle. There was a passenger in the vehicle. There was a overwhelming odor of marijuana. There was a probable cause search where MDMA and methamphetamine was located.
All right. I am not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial? You understand that?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Lockhart's done a good job of representing you competently?
Definitely.
Mr. Lockhart, do you know of any reason he should not enter this plea?
I do not, Your Honor.
Then Christopher Bryson in docket number 2024 CR 144, upon your plea of guilty to count 1, I find you guilty, sentence you to 8 years in Tennessee Department of Corrections that will be suspended on time served to community corrections. And count 2, you're sentenced to 8 years in community corrections. Those will be concurrent with one another, but consecutive to your violation of probation sentence out of Benton County. Thank you.
Judge, General Stribling wanted me to note that even though this mentions the VOP out of Benton County, our office has made no agreements on that VOP. It is handled by another district, and we don't have any control of that.
I understand. This does not affect whatever Benton County does in that.
Judge, I don't think I got to review and sign that plea sheet. It also needs to have the forfeit seized property.
I had General Stribling sign it. That's where I was.
Okay. Thank you, Judge.
All right.
I don't mind if the court just wants to write in forfeit property. I don't think that's in the police sheet.
It's not in the plea sheet, but we'll go ahead and. This is a motion for discovery as well as a motion for bond reduction. I assume there's no issues with the discovery, but rather we're just dealing with the bond reduction request.
Yes, Your Honor.
Actually not a request for a reduction because his bond was previously revoked by this court back in September, if I understand correctly.
Reinstate.
All right. Since it is a motion for reinstatement, if you'd like to present your proof, I'll be glad to hear you.
Call
Mr. Hunt, if you'll come up, please, to this podium, to that seat, If I can have you placed under oath.
Yes.
If you would state your full name for the court.
John Robert Hunt III.
Mr. Hunt, you know that your bond was revoked. Had you picked up some charges in another state?
Yes, my constitutional rights were violated.
All right. What state had you picked up charges in?
Buffalo, New York.
And ultimately, did you plead to reduce charges?
Yes.
And what were the charges you pled to?
Fines, tickets.
All right. And what was it? A moving violation, parking tickets? What was it?
Driving tickets.
Driving tickets?
Yes.
All right. And specifies that driving without a license? What kind of driving ticket?
Leaving the scene.
Leaving the scene?
Yes.
All right. And did you receive any sentence on those?
No.
Did you receive a fine and cost?
Yes.
Okay. Other than that, while you were out on bond, did you work?
Yes.
Where did you work?
Tops Distribution Center.
What type of work did you do there?
In the warehouse, like basically a grocery store. You go down the aisles, pick out the groceries. I build them on the back of a pallet. Then I send them at the door and wait for the trucks to come get them.
At some point in time, did you have a separation from employee?
Yes.
Due to being hospitalized?
Yes.
What happened?
I had got shot.
And where did that take place?
In Youngstown, Ohio.
Okay. Was that where you were a victim in a crime?
No, I was visiting.
Visiting?
Visiting a family member.
Okay. And someone shot you?
Yes.
While you were visiting?
Yes.
The employment you had, was that through Federal Express?
Yes.
Okay.
This is yes, these dates is right here is from 2022 and 2023 and 2024.
Okay. If the judge were to reinstate your bond, would you have a job available for you?
Yes, sir.
Would you have family support?
Yes, sir. My mom and dad is present in the courtroom right now as we speak.
All right. And would you have a place to live with them?
Yes.
Okay. And would you have transportation to get you to and from work?
Yes.
Would you work and stay out of trouble if your bond's reinstated?
Yes, sir.
Now, your family lives in, is it Georgia?
Yes, Atlanta, Georgia.
All right. And do you have any family here?
No.
Okay.
Well, I do. I do have a family member here. My grandma.
Okay. And is she in Dixon or?
Nah, she in Nashville.
Nashville, Davidson County?
Yes.
All right. Have you ever been diagnosed with any type of mental health problems?
No.
Do you have any mental health diagnosis at all?
No.
Do you take any mental health medication?
No.
So are you physically and mentally healthy?
Yes, sir.
Do you have a spouse, a wife, or kids?
I have a girlfriend, stepdaughter.
Okay. And where is your stepdaughter?
Buffalo, New York?
Buffalo, New York?
Yes.
So you've got family in Atlanta and New York.
Yes, sir.
And so you're kind of between both
Yes, sir.
here. While you've been in jail, have you had any incidents where you got in trouble, got locked down, or anything of that nature?
Yes, one time.
All right, what happened on that?
It was a fight.
Okay. And was that someone that attacked you?
Yes.
Okay. How long have you been in jail?
8 months since my bond been revoked.
All right. And how long were you locked up before you made your bond?
9 months.
Okay. During your time in jail, has that made an impression on you that makes you want to do right and stay out of jail?
Yes, sir.
Would you be willing to comply with any bond conditions the court might impose?
Yes, sir.
If they wanted you to wear a GPS monitor, for instance, would you do that if that's what it took?
Yes, sir. I had one on before.
All right. So before you revoked?
Yes, sir.
All right. So you'd be willing to do that again?
Yes, sir.
If the judge wanted you on restrictions like you could be home, go to work, go to the doctor, but nothing else, would you do that?
Yes, sir.
That's all the questions I have.
General Wojnarowski, you may cross-examine.
Mr. Hunt, you testified in September as well for the motion to revoke your
Yes.
bond, correct? And during that time, you agreed that you pled to reckless driving and leaving the scene of an accident, is that correct?
Yes, ma'am.
And do you remember when the state played evidence showing you driving on the sidewalk in the vehicle, admitting that that was you in the vehicle, driving on the sidewalk, and then you went and hit another vehicle head-on?
Yes, ma'am.
Okay. And you admitted to those crimes, correct?
Yes, but them wasn't the crimes I was, them was fines.
Okay, but you agree that you committed those offenses that they decided to give you just fines for, is that correct?
Yes.
Okay. And you were also charged at that time period with both a harassment as well as what they called a criminal obstruction of an airway?
My cousin lied because she knew I just came home.
I'm not asking whether or not
But
your
yes.
cousin lied. You were charged with that, is that correct?
Yes, ma'am.
And that was on separate dates than this other incident?
But that was dismissed.
It was actually taken under advisement where it was continued, was it not?
I just know it was dismissed when I went in front of the judge.
Okay. So you believe it was dismissed?
It was.
And then the documents that you have submitted to the court show that you last worked 2/15 of 2024, is that correct?
That's not when I last worked. This is my previous when I worked. This is previous when I worked. But I just worked. I worked from Tops Distribution Center from October 31st, 2024 until the day my bond was revoked.
Okay, but the documents that were presented by your attorney in front of this court was just in regards to your FedEx work and when you worked there, is that correct?
Yes, ma'am.
So we don't have anything from the Tops Distribution Center, is that correct?
I do have it.
But we don't have it here in front of us, is that correct?
Yes.
Okay. When did you say that you were in Ohio?
This was in June 2020. It's 2020. I can't remember the date, but I know I got shot. But it was in June. The day it was. Can't remember the date.
You don't remember what year you got shot?
No.
Did anybody get charged for that offense?
No.
Did you report it to the police?
Yes, they came to the hospital and seen me. 2023. I was 19.
Now, you would agree that you were
That
previously.
was I got shot in 2022.
In 2022,
Yes.
so prior to this offense that you're charged for.
What, the charges I'm here for now?
The conspiracy case that your underlying charge is. You were
Yes.
shot prior to even the conspiracy case.
Yes.
Okay. Now, you would agree that when these new offenses took place in Buffalo, New York, you were not wearing your GPS bracelet, is that correct?
No, because the jail didn't give me one.
Okay, and when you bonded out originally on this charge, that was a requirement for you to have?
But the person, just like before, when Roger Wainick was my lawyer, me and my mom brought the papers. We brought the papers to show you that I was paying whatever they gave me before I bonded out. And then the day you was revoking my bond, Judge Wolf rescheduled the date. Then the next day, me and my mom came, and I had an ankle monitor on.
Right, so in May of 2025 is when you got your ankle monitor on, is that correct? Does that sound about right?
May 2025.
Your bond was revoked in September of 2025, and you got your ankle monitor on in May of 2025.
Well, I just know I had got it on.
Okay.
But
All right, I don't have any further questions, Your Honor.
Redirect, Mr. Lockhart.
Yeah, approach it.
You may.
That reflect when you worked at Cops.
yes, sir.
And Your Honor, I apologize, I got that out of order. I'd move that and his other two employment records into evidence as a
All
collective
right.
exhibit.
We'll mark them as a collective exhibit 1 to this hearing. Any recross? Thank you, sir. You may step down and have a seat by your lawyer. Mr. Lockhart, you may call your next witness. You are being called as a witness. Step around, raise your right hand, and face the clerk and let her place you under oath.
If you would state your full name for the court,
Jasmine Danielle Hunt.
and what relation are you to Mr. John Hunt in this case?
He's my son.
You've heard his testimony about working and where he would live, those type things. If the judge were to reinstate his bond, would he be able to live with you and his father?
Yes.
Would y'all help make sure that he has transportation to and from work?
Yes.
If the court were to impose any conditions, such as wearing a monitor or restrictions on when he can leave the house other than for work, that type thing, would y'all help make sure he abides by the bond conditions?
Yes.
If you found out he was breaking the law or doing something wrong again, would you notify law enforcement?
Yes.
This is your last
Even though
chance
he's your
before
son,
trial.
you would do
Judge
that.
David
Yes.
Wolf got
That's all the
noticeably
questions I have.
stern with multiple
Gentlemen, do you have
defendants
any
during a
questions?
packed courtroom session filled with probation violations, plea deals, and heated
Ms.
warnings.
Hunt, do you
One of
live
the
with your husband
strongest
in
moments
Atlanta? Is that
came when the
correct? Or in
judge
somewhere in
warned the
Georgia?
defendant facing assault,
And
evading arrest,
Mr.
and
Hunt,
evidence
John
tampering
Hunt,
charges
was
that
living
the
in
next
New
court
York.
date
Is that
was
correct?
final
Yes.
before trial.
And at
He
the last
bluntly
hearing, I
stated,
believe he testified
"She's
he was
not
going to be
likely to
going
take
back
any
to New
excuses."
York.
Another intense exchange happened during a
Do you
bond
know where he
reinstatement
expects to
hearing,
go if this
when a
judge
defendant
grants him
tried
a
claiming
new
his
bond?
constitutional
Yes, my
rights were
mother
violated after
resides
getting
in Buffalo,
arrested
New
in
York.
another
So
state.
he's not going to live with y'all
Prosecutors
in y'all's
immediately
monitoring.
confronted
Is that
him with
correct?
evidence
If
that
he's
he
in
drove
Atlanta,
onto
Georgia,
a
he can come back to
sidewalk
Atlanta,
and
Georgia.
crashed head
Yes, he can
on
come back
into
to Atlanta,
another
Georgia.
vehicle
He was
before
in and out of
fleeing the
Buffalo
scene.
because
The
he was
courtroom
helping
got
take care
tense
of my
as the
dying
judge
grandfather.
carefully
And
questioned
then my
whether the
mom
man
had
could
hip surgery,
actually
so he
stay
went to
out
go
of trouble
help
if released
while my
again.
mom having hip surgery.
The judge
So that's why he
also
was in New York.
firmly
So
shut
would
down
he
a
be going
prisoner
back to
asking
New
to be
York?
reinstated onto probation
I mean,
after
if he can
already
come back to
being
Atlanta,
revoked
Georgia,
and sent
that's
to
no
prison.
problem.
Judge
I
Wolf
guess my
explained
question
there was
is that
absolutely
if
nothing
this
the court
judge
could do
today
anymore
said, yes, you're
because
allowed
the
to go
Department
out
of
and
Corrections
leave,
now had full
where is Mr.
control
Hunt
over his
going?
sentence. Meanwhile, another
you discussed
defendant
it with him?
representing himself
No, we have not
tried
discussed it, but he
flooding
can
the
go to
court
either
with
one. We have family in
motions,
both
subpoenas,
states.
and
Okay.
demands
Thank
for
you. I don't have any further
witnesses.
questions.
The judge stayed patient, but
Anything
finally
further?
reset everything for a later hearing after discovering the subpoenas had never even been served. The hearing was
Yes.
packed with pressure-filled plea deals, emotional testimony, and repeated courtroom warnings about wasting the court's
Yes,
time.
that's where he
before
was
trial
resigning
dates.
before he even went.
Ms. Blackwelder, if you'll raise your right hand, let's place you under oath. Thank you. State your full name for the record.
Emma Lawson Blackwelder.
Ms. Blackwelder, you're here on a violation of probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove that you had actually violated your probation and they would have to meet the legal standard?
Yes, Your Honor.
You understand if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, Your Honor.
Do you understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals? Now, by pleading guilty, you're waiving your right to contest the issue of whether you are guilty or not guilty of violating your probation. Do you understand that? But you are preserving the right to have a hearing on what should happen to you, more or less. You understand that? You understand that if we have that hearing on the sentencing portion, then whatever I do, you can still appeal what my decision would be and have a lawyer help you with an appeal to the Court of Criminal Appeals. You understand everything I've explained?
Yes,
You want to go ahead and enter a plea of guilty to the charge of violating your probation? All right,
If
and I
I
find
may-
she's guilty, but we'll go ahead and put on the proof about the disposition.
Thank you, Your Honor. And she's signing a plea sheet here, which admits her violation. And specifically, it's the new convictions out of Madison County, Tennessee. Those are in the first amended petition. She is admitting those violations only. Sit next to me, and then you have to go. But you're going to sit next to me.
All right, you want to call her as a witness?
Yes, please, Your
You'll
Honor.
come around, please, ma'am. You've already been sworn, so just have a seat. So, I changed it.
All right. Would you please state your name, ma'am?
Emma Lawson Blackwelder.
Okay. And you've admitted that you're in violation of your probation, right?
Yes.
And that's because of new convictions?
Yes.
Okay. What were those convictions?
Like the
In Madison County?
simple possession, paraphernalia, and theft.
Okay. And were you sentenced to probation on those?
1129.
Okay.
Misdemeanor probation.
Okay. And are you asking the court to reinstate you to probation today?
Yes.
Okay. How much time have you spent in jail on this arrest?
4.5 months.
Okay. And is this your first probation violation?
Yes.
Okay. When were you originally put on probation?
In 2022.
Okay. And if you were reinstated to probation, do you know where you would live?
Yes, I have a bed waiting for me at Archangel's Recovery Community House in Charlotte.
In Charlotte, Tennessee, is that right?
Yes.
Okay. And how long would you expect to be there?
I can stay up to 2 years there.
Okay. So you got new convictions. What was the circumstances of those convictions in Madison County?
They just read it at 11:29, run concurrent with what I'm doing here.
Okay. And you pled guilty to those charges?
Yes.
Okay. What happened?
In court or?
Just with the charges?
I was living in an Oxford house up there, and my probation officer I had a warrant for here. And so when I asked my friends to come get me to bring me back to here, they came up in a stolen truck and they stole a trailer while they were up there. And I didn't know about it because I'd been in rehab. And so they swarmed us at the gas station, and the dude who was in the truck ran. And so they charged us all with the same thing. And so it was either take it to trial or just take the charges. And so I just took the charges to run concurrent with here so that I could move forward with.
Have you stayed in contact with your probation officer?
Yes, I've reported every month since I've been in jail.
Okay. How about before that, while you were on probation?
I was reporting, and then I went to rehab and stuff. So.
Okay. Did your probation officer know that you were going to rehab?
Here, right, this probation officer?
Yes.
I haven't spoken to her yet.
Okay. And before you were arrested, did you have a job or anything like that?
I was working. I was working as a home health care. I was taking care of a lady at home.
Okay. And you said you were arrested approximately 4 months ago, 4.5 months ago?
Yes, sir.
On this violation?
I've been in jail since September 7th.
Okay. And was that on this violation?
Yes.
And do you think that you're going to benefit from going to, you called it Archangels?
Yes.
Okay. What are they going to help you with?
They help you get to and from work. They go to meetings. They drug test. It's a sober community house. So.
Okay. Now, you got in trouble. You got new convictions, right? Okay. Are you going to be able to avoid that in the future?
Yes.
Okay. What do you think's different now?
I was sober when I came to jail. I just got out of rehab. And so going to meetings and getting a sponsor and changing the way that I live and who I hang out with and the people, places, and things, I think it makes a big impact. And I'm just ready for something different in my life.
Okay. So you think that you would be successful on probation?
I do. I think I could complete it.
Is there anything else you'd like the court to know as far as your goals for you being on probation?
I'm really trying to live cleaner and healthier, and I'm trying to be back with my son. And I'm ready for something different. And I know that I can do it. I know I messed up, but I think if I was given the opportunity, I could really do it.
Okay. Thank you. I'll pass the witness, Your Honor.
All right. State may cross-examine.
Ms. Blackwelder, you said that you had just completed treatment somewhere, is that correct?
Yes, ma'am.
Where was that?
Jackson, Tennessee.
And what was the program?
JACOA.
And how long of a program was that?
30 days.
And when did you complete it?
In August, and then I went to an Oxford house.
And where's Oxford House?
It was in Madison. It was in Jackson.
Did your probation officer know you were going to all these places?
Well, I was also on probation in Williamson County, and so they sent me there. And so when I got there, I tried contacting her, but I couldn't get a hold of her.
So are you currently still on probation in Williamson County?
No, ma'am, I flattened that.
You flattened that sentence?
Yes, ma'am.
What was that for?
1129 misdemeanor probation for simple possession. But I'd been on that probation for a while.
Okay. And you're saying that you completed this in August, is that right?
Yes, ma'am.
Why do you want to go to treatment again?
I don't want to go to treatment, like the rehab. It's just a sober living house. And I think that it would help me keep me on the right track. And they help you get to and from work so I can save up to get my license back. And it's close to my family because my family lives in Ashland City, so.
Did you say it was in Charlotte?
Yes, ma'am.
Okay. Where is it in Charlotte?
I'm not sure the exact address, but I think it's over by the Amish store.
Okay.
It's on Old Charlotte, I think, Old Charlotte Road.
So you admit, obviously, that you just recently got 3 new convictions, is that correct?
Yes, ma'am.
The theft, the simple possession, and drug paraphernalia.
Yes, ma'am.
And what was the drug that you were in possession of?
They said that it was fentanyl, but it wasn't my possession. I didn't have it. It was just in the front seat of the vehicle so the dude that was in the car, the truck, he ran and he ran over the median and ran through all the traffic and everything. I wasn't in the vehicle, but my phone was in the front seat when he took off. And so because my phone was in the front seat, they said that I was in the front seat, and so they charged me with it, but it wasn't mine.
But the fentanyl was found in the front seat where your phone was, right?
It was in the floorboard, I guess.
Okay. And you were charged with another charge in Hickman County, is that correct?
Back in April of last year.
And don't tell me about it, because is it still pending?
Yes, ma'am. They won't come get me. I've written
Okay.
out to them 5 times, and my mom called up there too, and they said that they don't transport anymore.
Okay. But you have a current pending charge in Hickman County, right? For simple possession?
Yes, ma'am.
Okay. And you didn't report that charge to your probation officer, did you?
No, I did not.
And
Because I hadn't been convicted on it, so I didn't know that I was.
She's only admitted the violation as to the new charges. That's the basis for her violation.
And Judge, I'm not asking about the details of her crime, only about whether or not she was charged with it.
Well,
And then obviously about another basis of the other charge, I feel is
so that
appropriate.
if I'm understanding, there is a pending charge in Dixon County,
In
Tennessee?
Hickman.
Hickman County.
And that, Your Honor, is the basis, is the basis of her other, the other alleged violation in this case, and that's not what she's admitted.
Well, I think, again, she's admitted her violation. It's just a question of disposition. If it's still pending, what may or may not happen. So I'm going to overrule the objection, but she cannot be asked about the details of the crime.
Yes,
But
Judge.
I think the question of whether it is pending or not is relevant.
Yes, Your Honor.
Ms. Blackwelder, have you ever refused to appear for a drug screen?
No, I have, it says I didn't show up for the drug screen, but I never got a phone call, or I would have showed up, because I haven't failed a drug test since I've been on probation.
Okay, but you were using drugs, correct?
Again, I would object to this on the same basis, Your Honor. That's the alleged violation in the initially filed warrant.
Judge, I don't think it is an issue whether or not I can ask questions of this witness in regards to whether or not she admitted to that violation or not. It's still a relevant question.
Even if she's, well, number one, if she's admitted the violation, then she's more or less admitted that she was charged with violating her probation, and she's admitted that. And if she is asking for a disposition, then the question of whether or not she is or is not using drugs or has not used drugs is relevant. So overrule the objection.
Yes, sir.
So you said you never tested positive on a drug screen, but were you using drugs?
I smoke marijuana sometimes, yes, ma'am.
And that's why you went to rehab?
Yes, ma'am.
Okay. I don't have any further questions.
I have no redirect, Your Honor.
So you're saying that there is a sober living house in Charlotte, Tennessee?
Yes, sir. It's
And
on,
you're saying it's somewhere near the Mennonite store, Country View,
I believe so. I believe it's on Old Charlotte Pike.
but you've not ever been there?
No, sir, but I have a bed there.
You have a bed there?
Yes, sir.
And you have any documentation about that? Anything that, in writing, that says you actually have what this place is and what kind of reservation you have?
It's called Archangels. I was supposed to meet with the case manager yesterday at the jail, but she never came and got me, so I don't have anything with me.
Step down. Have a seat by your lawyer. Mr. Talbot, do you have anything else?
No, sir.
Defense is rested. Do the state wish to call any witnesses? Officer Bright, if you'll step around here and raise your right hand and be placed under oath.
Officer Bright, you are the supervising officer for Ms. Blackwelder, is that correct?
Correct.
And did you request a original violation of probation on Ms. Blackwelder?
I did.
And can you tell us what the reasons for the original violation were?
The original violation is for a citation that she was given in Hickman County for simple possession and casual exchange, and that she failed to report that, as well as she failed to report for her random drug screen on 4/17/2025. Those were the basis for that original violation.
Was Ms. Blackwelder instructed to appear to have a drug screen?
She was.
And she did not appear, is that correct?
She did not.
So she had notice to be there before
She
your
did.
office?
She even apologized through text message later that she missed her drug screen.
All right. And then on, did she provide you with any notice of this new charge in Hickman County?
No.
And I realize it's still pending. Do you know when it's set for?
I do not. I just asked Hickman if it had been disposed of. They said no.
Was Ms. Blackwelder supposed to be out of the county?
Typically, no, not without discussing it with us.
Okay. What about in the first amended violation of probation?
That is for a new arrest in Madison County, Tennessee, where she was charged with theft, casual exchange, and possession of unlawful drug paraphernalia.
And that's the one that she's admitted to the convictions of, is that correct?
Correct.
Okay. And was she supposed to be in Madison County, Tennessee?
No.
Did you know about these drug rehabs that she said she was at?
The only one I was aware of was Jacoa, and that the letter that I had received from Jacoa said she entered that on August 20th of 2025.
So you knew she was in Jacoa, which, was that the one in Jackson, Tennessee?
I believe that's where Jacoa is.
Okay. But did not have knowledge that she would be in Madison County or Hickman County?
No.
Is there any further information you think the court should know on Ms. Blackwelder?
I am not aware of any Archangel sober living or anything along those lines in Charlotte, so I'm not sure if that is even a thing.
Okay. Thank you. I don't have any further questions.
Mr. Talbot, do you have questions?
Is there a rule against a probationer leaving the county?
There is.
There is? Okay. Is it that they may not ever leave the county, or they just have to notify you
No,
of that?
it's not that they can't ever leave, but I can, let's see. It is one of the rules of probation. Rule number 5, I will get the permission of my probation officer before leaving my county of residence or the state.
And you testified that she didn't obtain permission to leave the county?
Correct.
Okay. I have no further questions. Thank you, Your Honor.
At the time that Ms. Blackwelder entered her plea back in 2023, one of the conditions was that she was to undergo an alcohol and drug assessment and follow treatment recommendations. To your knowledge, do you show if she's done that?
I believe I had her do one with our office.
All right. Thank you. You may step down. Anything further from the state? Any rebuttal proof, Mr. Talbot?
No, Your Honor.
Now I'll hear you an argument.
The court heard Ms. Blackwelder admit that she did violate the law and she got convictions for that. She took ownership of that. She was given a probation sentence in that case. That presents an opportunity for her, in this case, should she be reinstated to probation, to take advantage of that opportunity and go into sober living that she described. So she anticipates that she would be able to succeed on probation with the support of that sober living that she anticipates entering. And I would also note for the court that she had some significant time on probation where she did well. From the date that she entered her plea originally and was sentenced to probation back in the 13th of January 2023, all the way through she testified that she was arrested September 7. But the court could go through I suppose, the filing of the first violation warrant, which would have been back on 16 June 2025, when the state alleged that there were problems relating to her performance on probation. So that's a period of over 2 years, I think, Your Honor, January 2023 to June 2025. I would ask that the court, if the court does revoke her to serve her sentence, that she be given credit for that period in the court's discretion. The court has the authority to do that. Also, she's clearly shown that she put a lot of thought into trying to get her life together and succeed on probation by making this plan to enter Archangel's recovery house there. And she also has significant jail time that she served already, approximately 4.5 months by her testimony. That is a significant penalty, which the court could stand on in ruling that she's sentenced to the time she's already served. That would be a proportionate sentence for her in this case, followed by her reinstatement to probation. We ask that the court consider that, and then reinstate her to probation with any appropriate conditions. Thank you, Your Honor.
Your Honor, it appears that Ms. Blackwelder has chosen to continue to commit crimes while she's already on supervised probation. This was her opportunity to be successful, to take advantage of what the probation has to offer. She pled guilty to aggravated burglary and possession of marijuana as her original sentence back in 2023. She has now since been convicted of 3 new misdemeanor charges, including a simple possession, drug paraphernalia, and theft. She, according to the probation officer, she has another pending charge, which obviously has not been resolved in Hickman County on simple possession. She's failed to report to drug screens as requested by her probation officer and didn't report the arrest, as well as being out of county. I don't think Ms. Blackwelder is going to obey the rules of probation. It's pretty clear based on each of the rules that she has violated that it doesn't appear she is ready to be successful on probation. I would ask that she be revoked to serve.
Of course, always willing to try to give someone an opportunity to try to get help if they have a dependency problem. Not sure that Ms. Blackwelder has really gotten a grip on what her problems are. Clearly, she has violated the terms and conditions of her probation not on one occasion, but on multiple occasions. So for that reason, I find that she is guilty of violating her probation as she admitted, and that an appropriate sentence is to require her to serve 1 year, and following the service of 1 year with credit for time served, she'll be returned to active probation, but her probation will be extended for 1 year as well. So she's going to have an additional 1 year to serve on probation, and she'll have 1 year to serve with credit for time served. And that will be the judgment of the court.
Thank you, Your Honor.
Let's go to the Dixon County Jail. And I believe this would be Miss Connie Presley. is on page 18. Ms. Presley, can you hear me?
Yes, sir.
I think you're represented by Mr. Spratt.
Yes, sir.
Is there any way I could have Miss Presley? I didn't get the docket. I think I've been taken off the list. If I could have her brought down for second call.
Ms. Presley, your lawyer wants you to have you brought down, so I'll have you brought down as soon as we can get you here. So,
Thank you, Your Honor. Thank you, Mr. Lake.
saying he's been taken off the list. I'm not sure what list it is, but
The email list.
Presley, we'll see you in a few minutes, okay?
Thank you.
All right, we have another inmate here. Bring one on out. All right, if we got a female inmate, let's bring her out. Rebecca Miles, that's on page 16. All right, at the jail, what is your name, please?
Yes, Green.
Is that your client as well, Mr.
It
Flanagan?
is, Judge, and we are not ready to set it for trial yet. That's a general facilities case, so we need another status date.
Now let's go September 23rd. All right, next status will be September the 23rd. Let your lawyer continue to try to work on your case.
I'll be up to see you, Chad.
All right. Anything about a bond?
Well, that's what I'm gonna come talk to you about.
Okay.
Okay.
Thank you.
And we're waiting on Rebecca Miles.
Judge, I'm gonna have her sign the plea petition.
Okay.
And this will be a no contest plea with a sentencing hearing.
All right, Ms. Miles, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Rebecca Ann Miles.
Ms. Miles, you're here on a multi-count indictment in docket number 2025 CR 59, and then you're also here in 2025 CR 294 on a charge of domestic assault. It's been indicated that you want to enter a plea of no contest to 4 of the counts in the first indictment, and that the second one will be dismissed as a part of that along with the other counts. Have you seen or been shown a copy of those charges, talked them over with Mr. Flanagan and you, and he discussed the range of punishments you're facing as well as possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no, would you mute the jail for me, please? Well, it's indicated you want to enter a plea of no contest or nolo contendere. All that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result of that, the state will tell me what their evidence would be at trial, and I will use that evidence to find you guilty according to this agreement. You understand that?
Yes, Your Honor.
Understand that you have a right, however, to plead not guilty and to all charges and to have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, Your Honor.
Do you understand that trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial you and Mr. Flanagan could confront and cross-examine every witness the state calls to testify against you, and you can bring in your own witnesses by using a subpoena?
Yes, Your Honor.
At trial, you would be presumed to be innocent. You would not have to testify or prove anything. Do you understand that no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering a plea of no contest to these 4 counts, you're waiving your right to contest your guilt or innocence on those charges?
Yes, Your Honor.
You understand that that's going to result in 4 felony convictions, or 4 convictions, and I think it would be all one's a misdemeanor, and that at that point in time, we will then be setting a sentencing hearing for the court for me to determine what your sentence would be.
Yes, Your Honor.
You understand that?
Yes.
Do you understand that while you're waiving your right to contest your guilt or innocence to those 4 counts, you're preserving your right to appeal whatever I did in a sentencing hearing?
Yes,
Do you
sir.
understand that? Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to plead no contest according to this agreement and waive your right to a hearing?
Yes, sir, I do.
Are you satisfied with your attorney's? Oh, well, first of all, let me ask this. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that there are facts to support a finding of guilt in your case?
Yes.
And I need you to listen as the state tells me what their evidence would be if this case went to trial. If you'll step aside for just a moment, let the state come up to the podium.
Your Honor, if this were to proceed forward to trial, the state would intend to show that on or around January the 22nd of 2025, Ms. Sanders was operating a school bus for Nashville Christian. On the school bus was a 6-year-old with the initials KO. They were going down Highway 70 and were going to turn left onto Highway 96 in the left turn lane. The state would intend to show a witness coming from Highway 70 going towards Dixon before approaching the intersection, observed a red car being operated in a dangerous manner. Then when going around the curve, this red car ultimately struck the school bus, causing it to ignite and catch fire. The driver, Ms. Sanders, and the 6-year-old had to get off the bus and run up the hill to the nearby church for safety reasons. At that point, whenever officers arrived and on body camera, the bus is fully engulfed in flames. This did place Ms. Sanders and the 6-year-old at risk of serious injury. On scene, Ms. Miles had a gash on her head, but ultimately when Sergeant Deloach went to speak with her, he noticed a strong smell of alcohol from her. A blood vial was ultimately collected, showing her to have a .113 BAC. On top of mixing that with her oxymorphone, 9 nanograms of that as well mixed with it, which TBI would say would have a synergistic effect, ultimately enhancing the effects of each other, not simply 1 + 1. Inside of her purse, Ms. Miles did have a prescription for the oxymorphone, as well as a handgun. Ms. Miles is a convicted felon, and she has ultimately previously been convicted for aggravated assault, which would make this a Class B felony. This is notated on the plea petition. For Your Honor, ultimately, with the sentencing hearing, we'll be looking at 8 to 12 years, which will be the manner of service, and ultimately the length will be decided by Your Honor. As required under TCA 40-35-501, both the child endangerment as well as the felon in possession of the firearm are 100% offenses. That is notated on the plea petition. Those are the facts that the state would intend to show for purposes of the DUI with the .113 and the oxymorphone, the reckless endangerment of the bus driver, the child endangerment of KO, and the possession of a weapon by a convicted felon. Thank you.
All right, Ms. Miles, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes, Your Honor.
You still wish to plead no contest.
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel that Mr. Flanagan's done a good job of representing you competently?
Yes, Your Honor.
Mr. Flanagan, you know of any reason she should not enter these pleas?
No.
And we need to go ahead then and set a sentencing hearing. I do find that she is guilty in count 2 of driving under the influence of an intoxicant. Count 4, I find her guilty of reckless endangerment with a deadly weapon. Count 6, I find her guilty of child endangerment of a child less than 8 years of age. And count 8, I find her guilty of being a felon in possession of a firearm. We will then set a sentencing hearing. I assume that September would probably be as early as we can get that done. July. My criminal docket is on the 14th of July. VOP day would be 28th. We can set it at 1 o'clock on the 28th of July.
Yes, because I'll be in trial on the 7th.
Is the 28th okay? All right. Mr. Flanagan, is that all right for you?
It is, sure.
We'll set it at let's do it at 1:30 just to be safe, but 1:30. We need a pre-sentence report, yes. July this 28th. Right. Right. All right, at the jail is, are you Ronnie McCoy? You're muted. You'll have to unmute that device.
Yes, Your Honor, I was Brian McCoy.
All right, Mr. McCoy, your lawyer has asked that you be brought down, so we're going to bring you down so that you can hopefully dispose of this case, all right?
Okay, thank you.
Thank you.
Thank you, Judge.
Next up, I've got Tanner Bishop.
All right, you need to talk to Mr. Bishop. All right, we'll put it on the second call. You have another one, Sergeant? All right, bring him up, please. Good morning.
I represent Mr. Bradford. Judge, on Mr. Bradford's, we're still in discussion about his case, and we're just going to ask to second call it if possible.
All right, we'll put it on the second call. Bring us out another one. Brian Carmona. Mr. Atchison, are you ready on Brian Carmona?
What's up, big guy? Judge, I'm going to pass forward Mr. Carmona's plea petition as it relates to his VOP. And
All right. Shows that he is going to admit his violation of probation, waive the hearing, and be sentenced to serve his sentence with credit for time served.
That's correct, Judge.
All right. Mr. Carmona, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Brian Jesus Carmona.
Mr. Carmona, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove to the legal standard that you had violated your probation?
Yes.
You understand you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes.
Do you understand that if you went to that hearing and I found you guilty, you could appeal what I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're going to be waiving your right to the hearing and to the appeal? All I'm going to do is revoke you to serve your sentence with credit for all your time.
Yes, sir.
You understand everything I've explained to you?
Yes.
Do you want to plead guilty according to that understanding?
Yes.
And upon your plea of guilty, I order that you be revoked to serve your sentence with credit for all your time, and your lawyer has set forth all of the days that you're entitled to on this document, okay?
Yes, sir.
All right, thank you, Mr.
Thank you,
Atchison.
Judge. I'll get it to you as soon as they get it hooked up.
We heard from Crystal Wilkerson before we bring out Derek Dillard.
I believe they're back there speaking with him. I've got Kadarius Godwin.
Okay. Darius Godwin, page 6. All right, now I'm ready if you are. Just, if the public defender will cooperate by letting him have that table for us to have this hearing on Mr. Cardarius Godwin.
What?
All right. Yes.
Mr. Bishop is going to get a trial date on that helps the deputies if they can take him back. So,
All right, and we don't need Mr. Tyner Bishop brought out?
no, we don't. I've told him what we're doing. That's General Bryson's.
Right. Well, let's just go ahead, before we start this hearing, let's go ahead and set a trial date. You're wanting a trial date on the sex offender registry violation form, correct?
Yes.
State have a date in mind that you want to try Mr. Tyner Bishop on that charge? Probably looking at January.
Judge, I don't have your trial dates marked, so I think it's a one-day trial.
What about, is it one-day trial?
Yes,
Could be
Judge.
half a day. I think it's going to be non-jury.
January 15th?
That's fine, Judge.
January 15th. The OP will be moved to January 27th.
Thank you, Judge.
All right, we're back on Cordarius Godwin. Defendant's motion to reinstate bond.
Outset, we have an order for expungement for the case that was tried in January and February. And I'll call Mr. Godwin briefly, Your Honor, but just to go over some of the things in the motion. Briefly, Your Honor, just to recall the timeline of events as to his bond revocation, the state filed a motion in 2020 CR 192. Court had a hearing on February 21st of 2024, and court granted that motion and sua sponte revoked Mr. Godwin's bonds in the remaining matters, one of which was docket number 2021 CR 256. Which we had a jury trial in January and February, and Mr. Godwin was found not guilty. The basis that the state laid out for that bond revocation was a charge in Lawrence County that was dismissed. An officer passed away down there. That was dismissed. And a certified copy of, I believe, the affidavit of complaint in that case was entered over objection, and he's since been found guilty. Would note for the court that docket number 2020 CR 192 and 2020 CR 351 were not bond-on-bond crimes of allegations. He was arrested for one, bonded out. Another one that had occurred previously, he was arrested shortly thereafter. So he's been held, and if I'm not mistaken, he's done at least 2.5 years, maybe 3 years on these remaining charges. And his bond's been revoked without any cross-examination of any of that. So what we're asking today is that his bond be reinstated on the remaining matters, or a reasonable bond be set. And I can go ahead with that being said and call Mr. Godwin as to the
All right,
factors.
Mr. Godwin, will come around, please.
Could you state your name for the record, please?
Cordarius Godwin.
Okay. And Mr. Godwin, where are you currently being housed?
Dixon County Jail.
Okay. And how long have you been there?
2.5 years.
Okay. Did you do some time before that on this case?
Yes.
Okay. And now, was some of that time at the outset of the case where there was a capias issued for a failure to appear?
Mm-hmm.
Okay. And did we have a motion to reinstate your bond based on that being a communication error with Ms. Fordyce?
Yes, sir.
Okay. And was your bond reinstated based on that hearing?
Yes, sir.
Okay. Have you ever had any other failures to appear?
No, sir.
Okay. And were the charges against you in Lawrenceburg, were those dismissed?
Yes, sir.
Okay. And if you were released, where would you be living?
Lawrenceburg, Tennessee.
Okay. And is that an apartment?
Mm-hmm.
Okay. And did you live in Lawrenceburg while this case has been pending when you were on release?
Mm-hmm. Yes.
Did you fail to appear at any time for
No,
that?
sir. No, sir.
For any of these hearings?
No.
Okay. Would you be willing to wear an ankle monitor if you were released, if the court required that?
Yes, sir.
Okay. And any other conditions, would you comply with those?
Yes, sir.
Okay. And do you have other family in the Lawrenceburg area?
No, sir.
Okay. Do you have other family in the Middle Tennessee area?
Mm-hmm.
Okay. And who are some of those?
And the Tosca Gowan,
Okay. And where does she live?
Murfreesboro.
Did you stay in contact with her often?
Mm-hmm.
Is she in the courtroom today?
Yes, sir.
Okay. And how much bond could you afford if you were released?
I don't know.
Okay. Did you work while you were out?
Yes, sir.
Okay. What type of work did you do?
Cabinet installation.
Cabinet installation?
Mm-hmm.
Okay. Did you work at some restaurants?
Mm-hmm. I worked at Chili's.
At Chili's? And did you work at Applebee's?
Mm-hmm.
And you've stayed in contact with me anytime you've been out?
Yes, sir.
Okay. Would you continue to stay in contact with me?
Yes, sir.
Okay. Those are my questions, Your Honor.
General Bryson?
Mr. Godwin, you have a pretty lengthy criminal history, is that right?
Yeah, mostly from a juvenile.
Okay. When did you get your first criminal offense?
2007.
And that would be when you got your robbery, ag burglary, a second robbery, an aggravated kidnapping, a theft of property, and an especially aggravated burglary, an aggravated robbery, an aggravated kidnapping, and a carjacking. You got all of those in 2007, is that right?
Yeah, it says a juvenile.
And you were transferred to adult court?
Yes.
Have you ever failed to appear for a court date other than the one where there was a mix-up with Ms. Fordyce?
No.
Are you sure?
I can remember.
So you don't remember failing to appear in 2017 or driving on revoked here in Dixon County?
No, ma'am.
You don't remember pleading guilty to that, to a contempt of court in 2018?
No, ma'am.
So do you think, if your criminal history shows that, is it wrong or you just don't remember? No, different question.
It's a different question, overruled.
So are you saying if your criminal history shows that it's wrong or you don't remember?
I just don't remember that one.
Do you think your behavior in the jail has been good?
Yes, I'm in the honor pod.
Have you had any jail write-ups during your time?
Yes.
What have you been written up for in the jail?
Destruction of county property.
What did that involve?
I broke a visitation handpiece
Is that your only write-up in the jail?
that I was charged and found guilty of, yes.
Have you been written up for other things that you weren't found guilty of?
Yes.
What else were you written up for?
For letting somebody use my phone PIN number, but it was a mix-up.
Have you, during your time in the jail, have you ever had your phone privileges suspended?
No.
Where did you say you intend to work if you get out?
Well, I'm starting to go back to CDL school.
CDL school?
Yes, ma'am.
And where will that be?
Columbia.
Is that something you have to apply for?
I already started the application process.
Okay. So have you turned in that application?
Yes.
And when will you hear back on if you've been accepted?
I don't know yet. It's still in progress.
The place that you're going to live, will that be with other people?
Yes.
Who else will be living in that house?
Emily McCall,
Okay. Who is Emily McCall?
my girlfriend.
Does she have kids?
No.
Will anyone else be in the house?
No.
During your time in jail, have you maintained communication with Miss McCall?
Yes, ma'am.
Okay. Have her calling privileges ever been suspended to you?
No.
Are you sure?
Yes.
So you don't remember when her call privileges, her video call privileges were suspended?
Yeah, her visitation was.
Okay, why was her visitation suspended?
I don't remember.
Could it have been because of sex acts on those phone visitation?
Maybe yes.
A sex act? Is
Yes,
this a
Judge.
video call from the jail? Is that
Yes,
right?
Judge. So you don't remember or you don't want to say?
No, I said it could have been
It could have
sexual
been.
conversations.
Nothing further, Judge.
Mr. Spratt, do you have any redirect?
About 5 years.
5 years. And you've done how long in jail? You said 2.5 years this time. Do you know how much